This is a great paper, and it approaches a really important topic for reasons that John has just explained. I think the paper does two things. It explains the practice of prospective-only overruling and its advantages in a particular category of case. And then it deals with a number of particular objections to it, many of which seem to be based on limits on federal court jurisdiction. Well, once we accept the main premise that courts, and especially the Supreme Court, ought to overrule cases in this particular way, I think the author's answers to the doubts that have been raised about it, and some of which you've just heard, are very convincing. So mainly, I'd like to comment on the central problem that always attends prospective overruling, and especially on how it fits with the values of originalist interpretation. Well, as the paper explains, prospective overruling has been around for a while, and it responds to a particular problem that occurs whenever a court changes the law. Of course, usually, judicial decisions are to be applied both prospectively and retroactively. But any retroactive application of a new rule of law has, in fact, the potential to upset serious reliance that people have placed on the old state of the law. That's why, for example, legislation is just about almost always prospective only. Now, the problems of retroactive rulemaking can be reduced, if not eliminated, if the court holds that the new court is only going to apply to circumstances arising after the judicial decision. And the now overruled, the erroneous rule will apply to all the situations that occurred before the ruling. So it looks to be a valuable judicial tool, and as the paper makes clear, many state Supreme Courts have continued to prospectively overrule. I might add, by the way, that it's a relatively common technique applied by many foreign constitutional courts. And federal courts did it for quite a while, although now it has been pretty thoroughly abandoned. Well, what does any of this have to do with originalism? Well, as you've heard, John and Mike focus on the use of prospective overruling in connection with one particular kind of decision. That is where a court overrules judgments that had applied non-originalist constitutional interpretations. Interpretations that true blue originalists like us will want to correct and replace with the original meaning. But it's still going to be a new law, and the decisions may disrupt conduct and transactions undertaken based on the prior decision. So restricting the force of these corrective decisions to the future will, in at least a lot of cases, alleviate the disruptions, while at the same time moving us closer, if not all the way, to a world where the original Constitution is in effect. So it's a win-win situation. Well, then why did originalists, like Justice Scalia, so vehemently object to prospective judgments? Well, insofar as we think we ought to make the correct rules of the Constitution effective, we may find it hard in the very same decision first to declare a previous interpretation of the Constitution erroneous, and then turn around and declare that that wrong interpretation must still govern all previous transactions. Originalism, that is, presumes a single fixed Constitution, not a Constitution that means one thing for 1965 and something else for 2023. Well, in response to that, and you've actually heard John mention it, John and Mike engage in what seems to me to be a form of whataboutism. They note that Justice Scalia himself was prepared to maintain the force of precedents that rely on non-originalist interpretations when to do otherwise would be grossly disruptive. I think that's what he was talking about when he said he was an originalist but not a nut. So if Scalia's preference in those situations was okay, then we say it ought to be okay to abide the lesser departure from the original rules of just correcting for future cases. In all of these cases, in the cases Scalia would not overrule, and in the cases which McGinnis and Rappaport would partially overrule, we are giving legal effect to propositions that are concededly erroneous. And we're doing it for practical reasons. That is, for extra legal reasons. Well, I'll come back to that at the end. You can see why people attached to the value underlying originalism might believe this to be a dangerous practice. It is in tension, if not in contradiction, with those animating values. It's a concession, isn't it, that sometimes courts ought to behave as if some things are more important than the law. We might well worry that this kind of calculation won't be restricted to the narrow category of cases about which the paper talks. That is, decisions that partially reinstate original constitutional meaning. And in fact, it has been used in that way. So Mapp versus Ohio, now a likely target for originalist overruling, itself overruled Wolf versus Colorado. And its action, Mapp's action, became easier to do, easier to swallow, when the court in Linkletter versus Walker held it was only going to be applied prospectively. Using reasoning, that is more or less the same reasoning that John and Mike apply in this paper. Moreover, whenever we make it easier to overrule prior judgments, as this technique would do, we introduce an element of instability into the law. That's why Justice Scalia said prospective decision-making is the handmaid of judicial activism. The particular technique that John and Mike prescribed for a court in deciding whether to make an overruling judgment fully retrospective, prospective only, or indeed not to overrule at all, don't greatly alleviate this concern. I hope I'm not putting it too crudely, but it seems to come down to balancing the value of getting the law right against the disruption caused by upsetting reliance on the prior state of the law. Now, I always get worried whenever I read a law review paper which has the word balancing in it. In this paper, the authors, as they have done in their earlier work on dealing with non-originalist precedent, say we must decide if full overruling would generate, and you've heard this, enormous costs, and that's the phrase that they regularly use. And the measurement of both the value of overruling and the enormity of the costs is committed to the judges. Please don't think me cynical if I worry that judges charged with applying this formula won't be extremely constrained in making the evaluation. The authors justify running the risks in this balancing exercise by again referring us to an even worse situation, the even more flaccid formula that the Supreme Court has set forth in decisions on whether or not to overrule a decision. And I certainly agree that the court's record on the standard for overruling is a mess. And were the court to make a good faith effort to adhere instead to the McGinnis-Rappaport formula, things would be considerably more orderly. Still, I fear that this enormity inquiry may tempt judges whose intellects may be convinced, but whose wills might be weak. Let me add a last point about the nature of the suggested judicial technique for making those decisions. I've told you that it is an exercise of an extra-legal process. It's based on non-legal considerations. But the paper, the presentation, as well as earlier work by Mike and John, suggest that these are, or at least could be, legal rules, rules of common law, or rules that Congress might enact. And I agree it's possible that the occasions and procedures for overruling decisions of law other than the meaning of the Constitution might be regulated in this way. But those sources do not seem competent to create rules that control decisions that make constitutional interpretations. Recall what the core question is in these cases. Does the Constitution permit or forbid some action? If a statute is challenged on constitutional grounds and the court determines that it is unconstitutional, then can a statute, or even the court itself purporting to create some common law rule, make lawful those applications of that unconstitutional statute that occurred before the date of the decision? Wouldn't that be a case of demoting the force of the Constitution below that of the statute or common law rule? This may be another example of dealing with the inevitably, occasionally undesirable effect of applying the original Constitution by applying some kind of law behind the law. I won't call it general law. Doesn't this clash with the most fundamental aspect of constitutional government? I think most fundamental aspect of constitutional government, that there is a single, supreme, fixed, positive, written law. Thanks.
Thanks, Rick. So Rick's looking at this from a perspective of pretty much sounds like no precedent in constitutional cases. There may be some people in the room, there surely are some other people in the room who take that position, but it's not a very common one. So I suppose one can say, this is sort of looking into extra legal considerations to not apply the Constitution. So we in previous work, as Rick mentioned, have a theory of precedent that we set forward that basically says that following precedent is consistent with the Constitution. And so in this, we're really trying to assume that precedent is followed, right? Right now, and for many originalists, and certainly for the Supreme Court, they're going to be following non-originalist precedents because the fear of the reliance costs that would be undermined if they overturn them retrospectively. So we've already got that world of extra legal considerations. What we're doing is actually making that world more possible to move closer to the original meaning. So it's true, we're not as close to the original meaning in the Rick Kay, Mike Paulson world, but I'm not sure how many people live in that world, let's put it that way. So, I mean, one way to think about this is, as Rick said, Justice Scalia said, prospective overruling is the handmaid of judicial activism. And I would say originalist prospective overruling is the handmaid of originalism.
The only thing I would add is I would resist a little the idea that we encourage a balancing test in the sense that we don't balance the value of going back to the original meaning versus enormous costs. We think going back to the original meaning is always a transcendent value unless there are enormous costs. So the focus is on enormous costs rather than a value in between them.